The United Kingdom is due to leave the European Union in less than 2 years' time. The terms in which we will leave and our future relationship with the European Union depend upon negotiations that will begin in the near future. However, the initial negotiating positions of the EU and the UK are incompatible. For example, the UK wants to leave the single market, but also reach an ambitious and comprehensive free trade agreement with the EU for the future. It also wants full control of borders and migration. But EU leaders have said that you cannot cherry-pick. You cannot take the bits of the single market that you do like, free trade in goods and services, and then be exempt from the bits that you don't like, free movement of people. There is also likely to be disagreement about the divorce bill, that is, the amount the United Kingdom has to pay the EU for long-term spending commitments which the UK had already agreed to. So those are the kinds of things that will be discussed in the negotiations. Someone will have to compromise if there is going to be a deal. In this talk, I explain the legal and political framework for these crucial negotiations, because that framework will affect the outcome of the negotiations. There is both an external and an internal aspect to the negotiations. The external aspect concerns the process whereby the UK government negotiates with the EU and what they will negotiate about. The internal aspect concerns how far and in what ways the United Kingdom Parliament and the devolved governments can influence the UK government's negotiating stance. I will start with the external aspect. The procedure for negotiation is set out in Article 50 of the Treaty on European Union. The European Council, that's the body which consists of the heads of government or heads of state of the EU member states, will set negotiation guidelines for Brexit. Draft guidelines have already been published, and we can expect these to be adopted at the next European Council meeting on 29th of April. That's next week. Sometime after that, probably in June, negotiations will begin. The timetable is very tight. Realistically, a provisional agreement will have to be reached between the EU negotiating team and the UK government by early November 2018. After that, it will have to be considered by the European Parliament, which will vote on whether to approve the deal. Assuming that the deal is then approved by the European Parliament, it will then be agreed on behalf of the EU by the Council. Now that's different from the European Council. This is the body formerly known as the Council of Ministers. Importantly, it also includes representatives of the governments of all the member states. Finally, on 29th March 2019, the United Kingdom will leave the European Union. Now that is the date 2 years after the UK Prime Minister gave notice of the intention to leave, that being the time limit set by Article 50. I say that the timetable is tight because the issues are numerous and complicated. So numerous and so complicated that there is unlikely to be a clean break from the EU on 29th March 2019. Now, the time allowed for negotiations can be extended beyond the 2-year period, but that requires a unanimous vote of the other 27 member states. So it is much more likely that there will be some kind of deal that does take effect on 29th March 2019, but is also accompanied by extensive transitional arrangements under which particular aspects of European Union law and policy and particular practical arrangements continue for fixed periods of time after 29th March 2019. Withdrawing from the EU will not be a big bang. It will be a staged process. So who exactly will be involved in these negotiations? On the UK side, responsibility for preparing for Brexit is divided between 3 UK government departments. We have the Department for Exiting the EU, the Foreign and Commonwealth Office, and the Department for International Trade, with the Department for Exiting the EU having the leading role. On the EU side, there's a negotiating team led by its chief negotiator, Michel Barnier. However, all of the key institutions of the EU will have an input. So those are the European Council, that's the group of heads of government, the Council, which has a rotating membership of ministers of member states, the European Commission, and the European Parliament. The European Parliament has indicated the importance that it attaches to its role by appointing its own coordinator for the negotiations, Guy Verhofstadt. The basic structure of the negotiations will make it difficult for the UK to achieve its aims. There is a large number of veto players. Each of the 27 other member states will be considering what is in their own interests, as well as what they perceive to be in the interests of the EU as a whole. No one state can block a deal on its own, but the final decision to approve the deal requires a qualified majority. This means at least 72% of the votes cast in the Council, provided also that those voting represent member states which together comprise at least 65% of the EU's population. And in practice, this means at least 20 of the member states must vote for the agreement, but 2 or 3 larger states voting together would be enough to block any agreement. As well as the need to get enough member states signed up for any deal, the European Parliament needs to agree. That's a different ballgame, because the Council is a forum to represent governments. The Parliament is not controlled by governments, so the UK and EU negotiators need to come up with a deal that they can sell to the European Parliament as well as to the governments of the member states. Having said that, only a simple majority of the 751 MEPs is required. I will now move on to the internal aspect. What does the UK government have to do to get whatever deal it makes with the EU accepted within the UK and to give effect to it within the UK? Well, it's already been given authority by Parliament to give notice of intention to leave the EU under Article 50. That authority was given by the European Union Notification of Withdrawal Act 2017. That authority was used by the Prime Minister to give notice on 29th March 2017. The eventual agreement on leaving the EU will be concluded by the UK government as an international agreement. To give effect to that withdrawal agreement will require legislation. This is the so-called Great Repeal Bill that the government has promised. The Great Repeal Bill will remove the binding effect of EU law in general, but it will also translate much existing EU law into domestic law. It will also provide the legal basis for the continuing effect in the UK's legal systems of any rules of EU law that will remain applicable to the UK under any transitional arrangements. There are no specific statutory requirements to consult Parliament during negotiations, but there are certain key points at which Parliament may be able to give a view on the negotiations. One is the process for enactment of the Great Repeal Bill. Another is an opportunity to vote on the final deal which the UK government has promised that Parliament will have. That vote will be on a take it or leave it basis. However, ministers have stressed that they will not provide a running commentary on the Brexit negotiations. So we should probably not expect Parliament to make much detailed input to the negotiations. However, Parliament could, in theory, exert substantial influence through the normal means of debates, motions and committee inquiries. All of these are underpinned by the convention that ministers are accountable to Parliament. But thus far the government has had no difficulty in managing Parliament. Whether that remains true depends on a variety of political factors, including the result of the general election in June, which might substantially change the government's majority. The trickiest of the internal issues relate to devolution. We know that 62% of those voting in Scotland and 56% of those voting in Northern Ireland voted for Remain. This has led some to suggest that there might be special arrangements for Scotland and Ireland that are different from the rest of the UK. For example, that both Scotland and Northern Ireland might remain in the single market. Thus far, the government has ruled out bespoke deals for different parts of the UK. But even if there are no bespoke deals, there remains the question of how the devolved administrations can exert influence over the UK's negotiating position. As a matter of law, decisions on leaving the EU and on the UK's future relationship with the EU are entirely for the UK Parliament and Government. That is because foreign affairs is a reserved matter in the devolution legislation. Also, there is no legal requirement to obtain the consent of devolved institutions to any Brexit deal, nor is there a constitutional convention requiring such consent. Similarly, there is no legal requirement that the devolved governments participate in negotiations with the EU over Brexit. However, the Prime Minister has emphasised that the interests of all parts of the UK will be taken into account and that the devolved administrations will be fully involved, although that is not a legally enforceable commitment. There are, however, non-statutory arrangements for their involvement. There is a joint ministerial committee on European Union negotiations, which is chaired by the Secretary of State for exiting the European Union. Its members include ministers from each of the UK devolved administrations. The Joint Ministerial Committee is supposed to try to agree a UK approach to and UK objectives for the negotiations, and to consider proposals put forward by the devolved administrations. Thus far, there is little sign of compromise from the UK government on any of the points on which the Scottish Government wants a different approach. The Northern Ireland situation is covered in a separate briefing. To further complicate matters, Brexit may lead to changes in the devolution settlements. The UK government has not guaranteed that all the powers currently devolved will remain devolved after Brexit. It has said that common UK frameworks may be required where they are necessary to protect the freedom of businesses to operate across the UK's single market and to enable the UK to strike free trade deals with third countries. So, for example, there may be powers that are currently devolved in terms of the Scotland Act of 1998, which are taken back to UK level as a consequence of Brexit. This is where the Sewell Convention comes in. This convention says that legislation relating to devolved matters and legislation altering the competence of the Scottish Parliament requires its consent. So taking powers back to the centre requires the consent of the Scottish Parliament. However, the Scottish Parliament is unlikely to agree to its powers being reduced. This would leave the UK government with the choice of backing down or of forcing the legislation through without the consent of the Scottish Parliament. That might increase constitutional conflict within the UK and place unwelcome pressure on a UK government facing the already tricky task of negotiating Brexit. I will finish by referring to the wider international context of the Brexit negotiations. The outcome of the Brexit negotiations will affect other international negotiations. The United Kingdom government has said that it wants to expand our overseas trade by pursuing new trade deals with countries outside the EU. There are several complications here. First, we currently have trade deals with many countries by virtue of our membership of the EU. As soon as we leave, we will lose our rights under those deals, and until we negotiate new deals, we would have to fall back on the World Trade Organization rules. Secondly, our current membership of the WTO depends on our membership of the EU. Once we leave the EU, we cease to be a member. Current WTO tariffs, etc., would cease to apply, and the UK would have to apply for membership of the WTO. Third, membership of the WTO will impose constraints on what trade deals the UK can reach. WTO tariffs work on a most favoured nation status. That means all members of the WTO get the best available tariff. We can't offer a better deal to India, for example, in the areas covered by WTO rules, than we can offer to other WTO members. This takes us back to the EU. The UK government also wants a new trade deal with the EU. That deal will have to be compatible with WTO rules. And even apart from the legal requirements, any country we try to negotiate a deal with would want to know what deal we will have with the EU, because EU countries will be trade competitors for access to UK markets. Fourth, there is the question of timing. The UK cannot agree a trade deal with a third country until after it has left the EU. Preliminary talks before Brexit will not get very far because non-EU countries will not know what our post-Brexit relationship with the EU is going to be. Indeed, that position may not be clarified for several years after Brexit because trade deals are difficult to agree at all and always take a long time. But even though new deals will take a long time to conclude, the UK government needs to be very careful of how its approach to those negotiations, that is the Brexit negotiations, might affect these longer term trade deals.